Hello everyone, my name is Maxim. I'm a legal operations specialist here at Howley. And today we'll be discussing mediation in the United States legal system. Mediation as a legal phenomenon, mediation as a legal procedure, and the questions of its legal regulations on the federal and state levels. So let's begin. Let's begin with concepts and definitions. What is mediation in the United States legal tradition? In the United States, mediation is understood as a voluntary and confidential process in which a neutral third party, the mediator, assists disputing parties in reaching a mutually acceptable resolution without imposing a binding decision. It's meant that parties are reaching a mutually acceptable resolution for their legal conflict. Okay. As you can see, it is said that mediation is voluntary and confidential process, and I think with the second part of this phrase we may agree completely, but as we'll see throughout this lection further, it's not always a voluntary voluntary procedure, but that's like that. So the key features of mediation as a legal phenomenon are voluntary participation, confidentiality, party autonomy in decision making, procedural flexibility, and neutrality and impartiality of the mediator. Let's dig in some history. Why did mediation appear at all, and why is it such a popular alternative dispute resolution instrument right now? So, in the period from 60s to 70s of the 20th century in the United States, growth of ADR existed in response to court congestion. There were just too much cases in courts. Small claims cases, different civil cases, different family cases, of course. And so that courts just couldn't handle such an amount of cases. And people started themselves to started trying to resolve their legal conflicts in different ways than just throughout the court hearings, since they just did not want to wait so much. So that the growth of alternative dispute resolution instruments began. In 1976, a Pound Conference took place. This was for mediation as a legal phenomenon and as an instrument was a milestone, since in the in that period of time, the parties of that conference recognized institutionally alternative dispute resolution instruments, including mediation, which means that courts just agreed that people have right to alternatively resolve their legal disputes, and with the agreements that are a result of alternative dispute resolution, they may go to courts, and courts may make such an agreements binding for the parties throughout court decisions. In 1980s and 1990s, the expansion of court-annexed mediation programs took place, and right now mediation is just a standard component of judicial case management and corporate dispute resolution. Like corporations like it very much, to be honest. So what's the legal framework of mediation? As we can see on the federal level, we have only one young legal act. It's called Alternative Dispute Resolution Act of 1998. its age is the same as mine. Its provisions encourage the settlement under the federal rules of civil procedure. So, the federal rules of civil procedure, when one is using the ADR Act as a basis for mediation procedures, the federal rules of civil procedure play a role of a procedural guideline for resolving legal conflicts throughout mediation on the federal level. And also, it obliges courts for mandatory creation of ADR programs in federal district courts. So, like any federal district court, including Supreme Court, also it's not district, but still has to have the ADR program for dispute resolutions. Regarding in-state specifics, almost any state throughout the United States has their own Mediation Act. Such acts may be called differently, like the Uniform Mediation Act of Colorado that you can see in here, or Louisiana Mediation Act, or Uniform Mediation Act of Missouri, and so on and so forth. The thing is that such acts generally regulate mediation in these two ways. First, they establish the criteria of eligibility for mediation, and the second is they sometimes prescribe mandatory mediation in different types of legal cases and legal relationships. So generally, uh, legal relationships that inside of which the mediation of as a procedure may be established in the United States may be divided into two big groups. These are general civil legal relationships and specially regulated administrative and public legal relationships. Also, civil may be a part of such group. So, when we are speaking in the regard of general civil legal relationships, the mediation that may exist inside of them is the court annexed mediation, when court generally prescribes uh, parties prescribes the mediation procedure for parties without their voluntary consent. Private mediation, when both parties just agree that they want to resolve their conflict throughout mediation. And family mediation, there's the specific procedure that exists inside of a family dispute resolution legal relationships, but we don't need to specifically point on that procedure, and it does not differ from any other mediation procedure. But under federal statutes and local court rules, a judge has a right to refer a case to mediation without party consent, stay litigation deadlines during mediation, and require good faith participation. So in most states, participation in the process of mediation may be mandatory under the court decision, but the settlement throughout such a procedure is always voluntary. So when one of the parties does not like the outcome of their case resolution throughout the mediation process, such a party may just not agree to these results and just continue with general litigation in the court. Regarding the second group, the mediation as a procedure in these cases is much more regulated. These cases include labor and collective mediation, what is also called collective bargaining procedures that we discussed in previous lecture, and also mediation in public law disputes. So we'll dig into these uh, uh, legal relationships and mediation inside of such legal relationships further, and we'll dig into them deeper. But as far as you can see, the question of the differences between mediation procedures does not refer to the sphere of law. Like, is it family law or civil law or administrative law? It more refers to the question of the level of legal regulations in specific legal relationships. That's the thing to be remembered. So, now let's speak about the mediator. Who is that? Mediator is a third party that does not render a decision in a mediation procedure, does not represent either party, facilitates communication and interest-based negotiation between parties, may be lawyer or maybe not lawyer depending on state rules, and also depending sometimes on uh, parties' willingness. Certification and ethical standards for mediators are mainly established on the state level. In some states, anyone may be a mediator. In some states, a mediator may be only certified person that went through specialized training and adheres to codes of conduct that exist in such a state in the United States. So here we do have a breakup of generally basic mediation procedure. Like in practice, this procedure is much more complex, but we have a breakup of a basic mediation procedure that exists in the United States. What does the mediator do? Mainly mediation is the job of a mediator. The first thing that he does or she does with parties is the preparation and mediation agreement. Then opening joint session begins, or sessions. There may be a few of them. Joint meetings and private caucuses are being held. Then the generation of and evaluation of settlement options is being done. And in the end, and everything, if everything is successful, the thing is, the parties have to reach and formalize an agreement. Formalizing an agreement is the final stage of any mediation procedure when they have a written agreement that is signed by both parties. And such an agreement, if parties wish so, can be made mandatory for them throughout court decision. But we need to dig in more into mediation in public law disputes and court-ordered mediation things. So the ADR that we've discussed before, the Alternative Dispute Resolution Act of 1998, requires every federal district court to establish ADR programs, ADR procedures, including mediation available in civil cases, and also inform litigants about the ADR options. So regarding mediation in federal public law disputes, I need to mention that it's also pretty popular way of resolving disputes, even in public law disputes. So that mediation involving federal agencies is subject to important limitations. Why? Because of the legal nature of public disputes and administrative law. It's much more regulated than the civil law as a sphere of law, and civil litigation as the question of legal regulations. Legal regulation inside public law and administrative law are much stricter than in any civil sphere. So the thing is that mediation, when federal agencies are involved, is subject to the limitations. First, the mediation has to have a key point of protection of the public interest. The second is that there exist statutory limits on agencies' discretion in decision making. The third is that there exists a prohibition of settlements that are contrary to law and public interest. Nevertheless, mediation is commonly used in such disputes, involving regulatory compliance, environmental permits, licensing and administrative enforcement, implementation of federal programs, and so on and so forth. I guess you've all seen in movies mediation procedures that exist with the Secretary of State in the United States when uh, for example, Tony Stark comes to the Secretary of State, and there are a lot of people sitting in there, and they discussing some things. This is the example of such a mediation procedure. So that because also in public legal relationships, mediation does also exist. Of course, there exists the Federal Mediation and Conciliation Service, FMCS. So let's dig in the functions and dig in into their mediator's special features, I'd rather say. So, what do they do? First of all, they mediate collective labor disputes. Secondly, they facilitate of negotiations involving public authorities. Also, they assist in complex multi-party public disputes. And also, what they do, they train and certificate mediators, like all mediators. That if a mediator has a desire to work as a mediator in the United States on a federal level, he or she has to be certified by FMCS. Regarding the mediators that work in them, they are neutral professionals. Despite FMCS being a federal agency, they do not represent the government. They adhere to strict confidentiality standards and they specialize in high stakes public and labor disputes. That's what they do. Uh, According to Federal Judicial Center, nowadays, most federal district courts authorize mandatory referral to ADR. In many jurisdictions, participation in mediation or related ADR procedures is effectively required. Courts consistently distinguish between mandatory participation and voluntary settlement outcomes. Uh, Also, what is interesting, the United States Supreme Court has not established a single precedent mandating mediation nationwide. However, a court-ordered mediation is widely recognized as compatible with constitutional right of access to courts. Make your own opinion on that. Um, so, what's the advantage? What are, I'm sorry, advantages and criticism of mediation? Advantages are they reduce court caseloads. That's understandable. Lower costs and faster resolution, preservation of relationships between parties, and higher voluntary compliance with settlements. Why is being mediation criticized? Because of potential imbalance of power between parties, which is understandable, limited judicial oversight, and possible misuse of confidentiality. Sometimes it is being used, like even in past the Watergate scandal that took place in the United States could had become possible because of the failed mediation procedure. To be honest, you may read regarding that online more. So, what is the future of mediation in the United States? As you see it is as a procedure and as a ADR instrument, it is widely used and uh, to be honest, made mandatory also. So that mediation is becoming a standard of court procedure, not merely as alternative. Unfortunately, courts increasingly use mandatory referrals while settlements remained voluntary. Expansion into public law and administrative disputes is expected in the future. That's understandable why. Online and digital mediation will play a growing role. It is playing a growing role right now, but to be honest, experts in the United States legal field expect it to just blow up in I'd say next 10-15 years. Higher professional and ethical standards for mediators are emerging, and the key challenge is balancing efficiency, fairness, and party autonomy in the mediation procedure. So, mediation in the United States, particularly in public law disputes, is not merely a voluntary alternative right now, but an institutionally embedded element of judicial procedure. That's how the mediation exists nowadays. Federal statutes, court rules, and state practices demonstrate a model in which participation in mediation may be mandatory, but settlement outcomes remain voluntary. The state actively supports ADR without undermining judicial and independence, and this approach is of substantial importance for comparative law and for reforming civil and administrative justice systems. And what will be the outcome? I don't know. We'll see. All in all, thank you for your attention. Thank you for listening and watching to this lecture. I hope you found something helpful and interesting for you and took it into your brain. So have a nice part of the day that you're having. Goodbye and see you in next lectures.